It's a long table, right?
Yeah. But during 90 parties are good distance. What do you really good?
Yeah. Good afternoon, everyone. We are prepared to begin. However, I'm noting that the interested party has not yet resumed. So I am given a little, we're waiting a little more to allow the interested party to join the session.
Mr. Chair, apologies, appearances as before, please. The representative for the interested party is logging on right now, please.
Thank you, Ms. Sina.
Mr. Chair, please, representative for the interested party, Ms. Christina Bermudez-Lucky, is before you, please.
Thank you. Little housekeeping. Right.
Following the matter of CP 2024-28, Agostini Insurance Brokers against Trinidad and Tobago Civil Aviation Authority and Gallagher Insurance Brokers Trinidad and Tobago Limited.
Good afternoon once again, everyone. Before we continue, some housekeeping. Seeing that Mr. Kevin Bryn is in the proceedings, but his camera is off. We would like all cameras to be turned on, please. I'm also noticing a username from Dana Marie Smith. The camera for that user is also turned off as well. Mr. Bryn?
Yes, apologies, Mr. Chair. Mr. Bryn he's just about to turn his camera on. Thank you.
Yes. Great. So let's begin. Representative for the applicant, have you reviewed the documentation that would have just been submitted?
Yes, please. I apologize, Mr. Chair. I interrupted you. I didn't mean to.
Please proceed. You have reviewed the document. Have you had sufficient time to review the packages? And
yes, I believe that I've had sufficient time, Mr. Chair. What I would appreciate is the documents really have been disclosed in somewhat of a vacuum. I know that my friend indicated that there was need to put in some further evidence. There was reference as well to rights of innocent third parties. But while I do have a tentative position with respect to the documents, I wonder whether the panel would perhaps permit the respondent to submit as to why these documents are being admitted. So what is the purpose for which the documents are being admitted, or they are seeking to admit these documents into evidence, and really what the relevance is, because I don't know that that has yet been stated, or perhaps I missed that.
noted, Ms. Fitzpatrick. Representative for the respondent, Ms. Rose. Before you continue, Ms. Rose, we are seeing you very far away from the camera. Could you remind us who are accompanying you? I'm seeing a gentleman to your right, and you may have introduced the person on your left before. Could you just refresh the memory of the panel?
Yes, please, Mr. Chairman. On my left is Ms. Dina Marie Smith, who instructs me on behalf of the respondent. And on the right is the accounting officer for the respondent, Mr. Price.
Thank you, Ms. Rose. You may proceed. Could you enlighten us as to the rationale for the documents being submitted, as well as the purpose for which the panel would have to consider them?
Yes, please, Mr. Chairman. The documents that were submitted are the aviation insurance policy in relation to this RFP and the motor vehicle insurance policy. These were negotiated and settled prior to the suspension order of the honorable panel. The respondent was notified of these arrangements having been put in place by the broker, who received a letter of appointment as broker on August 29th, and also received verbal confirmation of him being selected as the preferred bidder on August 16th. Pursuant to those communications on August 16th and August 29th, the broker initiated negotiations with various insurance providers. And prior to, and this was all done prior to the suspension order, the respondent, TTCA, only received notification of these policy arrangements on the 30th. I think that was the aviation policy, and the motor vehicle policy on the 27th. These two policies, with respect to the health, general health, the group health and life insurance plan, those were not, those were stopped, those were not entered into by the TTCA, but these had been expedited by the broker prior to the suspension order because of the urgent public interest considerations that apply with respect to the aviation insurance policy and the motor vehicle insurance policy. We think that this is significant, having regard to Section 6.2 of the Public Procurement and Disposal of Public Property Act, number 1 of 2015 as amended, and the applicant's request for relief in the form of cancellation of the contract and a reevaluation. Our respectful submission, and I would like leave to put the law before this hearing panel, not today, because I mean, I really got this information in the last few hours, but we will be seeking leave in the closing submissions to put the law in respect of the intervention of innocent third-party rights in a situation such as this that is recognized by Section 6.2 of the Public Procurement and Disposal of Public Property Act. My learned friend has quoted in her submissions her reliance on Section 6.1 of the Public Procurement and Disposal of Public Property Act, which says any procurement that has been done not in compliance with the Act would be rendered null and void. However, Section 6.2 says, notwithstanding subsection 1, this shall not affect innocent third-party rights. We are saying that these aviation and motor vehicle policies that were entered into have now brought into the foray the innocent third-party rights of the insurance providers, who now have rights, and the beneficiaries of those policies as well, which particularly in respect of the aviation liability policy is very significant, would include the government of Trinidad and Tobago and the citizens of Trinidad and Tobago. So this was the reason why, when the information came to me, it was clear that it was necessary to put this before the hearing panel in respect of the reliefs that have been sought by the applicant.
Thank you, Ms. Rose. For the benefit of the panel, could you advise us as to why these were not brought up at the case management conference or prior, given some of the dates mentioned, the 29th of August, the 16th of August?
I will have the witnesses, particularly Ms. Rhonda Suklal Singh, who can speak to the situation that led up to that, but I was only apprised of this information in this way in the last 24 hours. I'd say last 12 hours.
Thank you, Ms. Rose. We would address when the witnesses are presented. Ms. Fitzpatrick, any comments?
Yes, please, Mr. Chair. I'm grateful to my friend for that clarification, and I suspected that may have been the basis for adducing or seeking to adduce the evidence, but I didn't wish to speculate. Having had an opportunity to peruse the documents disclosed, the applicant will be objecting to them being relied upon by the respondent, please, for two main reasons. The first reason is the late disclosure of these documents. The second reason is the documents' irrelevance to the issues in this case or in these challenge proceedings. I'll turn first to the first objection. The hearing rules and procedure for Part 5 of the challenge proceedings, please, Mr. Chair, the relevant sections, I don't propose to read them for you, 8.1, 8.5, and 9.9, essentially say that a party who fails to make disclosure at the relevant time cannot seek to introduce or to rely upon the evidence at hearing without the leave of the hearing panel. And I appreciate that it says which may be granted on such conditions as the hearing panel considers just. And that is the same for a witness testifying to materials which were not disclosed. In answer to whether to admit this, or in considering rather whether to admit this evidence, we submit to this panel that you ought to consider the length of time that has passed since these proceedings were filed and the deadlines given by these panel, which of course take place within a short time frame. The claimant's application was filed on the 19th of September 2024. The respondent's reply was filed on the 27th of September 2024. In those circumstances, all of the documents being relied upon were to be disclosed by 27th September 2024 when the Form 9 was filed, please. Witness statements have now been filed. One of the respondent's witness statements, in fact, was filed out of time. The applicant has been extremely accommodating and reasonable, taken no objection to that. Submissions have been filed based on the cases set out by the parties in the Form 8 and Form 9, and the time for introducing evidence simply has passed. Further, we say that the panel must consider that this being such a recent procurement, and according to the respondent, one that was required to be completed with extreme urgency, this information must have been readily accessible to it. And I appreciate that my friend said she has only received it within the last 12 or 24 hours, but it is clear from the face of the emails that have been disclosed that these documents were exchanged in or around, I believe it's the 25th of September. There are attachments to those emails dated the 20th of September. So the respondent ought to have disclosed them promptly and indicated the issue that it now seeks to raise at the earliest possible opportunity. So essentially, we say that the respondent has failed to comply with its duty of disclosure and is coming now at this 11th hour to ambush the applicant with new documentation, which the applicant cannot address by way of evidence anymore to allow the evidence. And we say to allow the evidence under any circumstances or any conditions would simply be unjust. I turn now to deal with the irrelevance argument, please, Mr. Chair. And simply we say, well, we now understand the respondents' mention of the concern of innocent third-party rights is being raised with reference to Section 6, subsection 2 of the Act. And I would just like to read that for clarity, if you'll bear with me. Section 6.1, which, yes, the applicant does rely upon, of the Act states that subject to subsection 2, any procurement of goods, works, or services or retention of disposal of public property that is not done in accordance with the Act, and any procurement contract or agreement that is not entered into accordance with the Act is void and illegal. Subsection 2 states that nothing in subsection 1 shall affect the rights of an innocent party. I pause there to say that subsection 2 arises on the basis that the procurement has been conducted in breach of the Act. So that acceptance must be there. I don't know if my friend is raising innocent third-party rights in the alternative, but I assume it must be so, unless the respondent's case has changed. The respondent has now disclosed documentation passing between WTW and Gallagher, which show that WTW is providing insurance to civil aviation for the period 2024 to 2025. It should be added that these documents, Mr. Chair, do not support any evidence that has already been filed by the respondents. It does not support or do not support any of the respondents' raised in the form. The respondent appears to be seeking to submit that even if it was in breach of the Act, the award of the contract to Gallagher, and I say even if it was in breach of the Act because subsection 2 will only arise in those circumstances. The award of the contract to Gallagher could not be overturned or cannot be overturned because it would affect the rights of innocent third parties. Subsection 2 of Section 6 does not help this respondent in any way, please. In fact, it does quite the opposite. That section preserves the rights of innocent third parties, for example, WTW, against the person with whom it has contracted. And this, Mr. Chair, is, I say, best illustrated by an example. Where a contractor who's awarded a contract by a procuring entity in breach of the Act awards a subcontract to a third party who is not aware of the breach, who is innocent, that subcontractor's rights are enforceable against the contractor. Subsection 2 does not serve to render valid a contract between a procuring entity and the contractor where there has been a breach of the Act by the procuring entity. That is not what that subsection does. If this respondent's argument were to be accepted, it would mean that anyone that enters into a contract in breach of this Act could rectify that breach by simply rushing and awarding a contract to a third party and saying, well, this must be valid, otherwise the rights of innocent third parties will be affected. That could never be the intention of the Act. And for those reasons, we say that the panel should dismiss the respondent's applicant to adduce further evidence, and for these documents to be admitted or relied upon by the respondent.
Thank you, Ms. Fitzpatrick. Interested party, do you have any comments? Interested party or representative for the interested party?
No, please, Honorable Chair.
Thank you. Given the information just presented to the panel.
Mr. Chairman, may I be permitted to respond to?
Yes, Mr. Rose, you may. Yes.
Yeah. Mr. Chairman, what is before us is a hearing pursuant to the Public Procurement and Disposal of Public Property Act, which has a particular purpose. And you, as the hearing panel, you have your hearing rules. Ms. Fitzpatrick seems to think that this hearing is a court of law. My first submission is that issues relating to what is just should not be based on principles relating to what portends in a court of law. It should be in accordance with the hearing rules of this panel, which of necessity is far more broad and flexible in its remit in making decisions that are fair and just, having regard to the overriding objective. Moreover, the nature of these proceedings having to be completed within 20 days, and the orders having been made by this hearing panel on October 4th for witness statements, for disclosures. Well, there was no order for disclosure, but for witness statement and submissions to be made. There was no order for disclosure made, so it is incorrect for Ms. Fitzpatrick to be using the disclosure rules that apply in a court of law. And the times for disclosure in courts of law. There is nothing in the rules of this hearing panel that precludes the disclosure of documents pursuant to applications made by parties. And I would ask the hearing panel to conduct itself in accordance with its own rules. And your own rules, Mr. Chair and honorable and members of the panel, state that you have the power to regulate your own procedure, that is 4.8, and you shall conduct the hearing fairly, having regard to the principles contained in the overriding objective. In the overriding objective at 2.1, it says the overriding objective is to enable the hearing panel to deal with cases fairly and justly. And it's actually quite explicit what fairly and justly includes. Fairly and justly at 2.2a includes dealing with the case in ways which are proportionate to the importance of the case, the complexity of the issues, the anticipated costs and resources of the parties. So when we are thinking about what is just here, these are the elements the hearing panel must address their mind to. The second, and I will be submitting on these, but I want to go through 2.2b now. Fairly and justly includes avoiding unnecessary formality and seeking flexibility in the challenge proceedings. C, ensuring so far as is practicable that the parties are able to participate in the challenge proceedings. D, using any special expertise of the hearing panel effectively, and E, avoiding delay so far as compatible with the proper consideration of the issues to be determined in the challenge proceedings. And these rules are not there for fluff. These are not the rules that apply in the courts of law in Trinidad and Tobago. These are far broader. This panel has far more power to be flexible in these circumstances. And I am respectfully submitting that this is a case, and a singular case, as we go forward, it will emerge. This is a case for that flexibility, for that exceptional circumstance that we will be sharing with you today. So first of all, let's look at the principle of proportionality, which is a principle that is well known. It's a foundational principle in terms of how public sector bodies make decisions. We must see that their decisions are proportional to the harm that will be done to citizens in society and to parties, citizens' interests and citizens' rights. And that in principle of proportionality, I am raising in these proceedings in support of the decisions that the Trinidad and Tobago Civil Aviation Authority made during the course of this process, but also as your rules mandate to guide this hearing panel in terms of how you treat with decisions such as this and applications such as this. Applications to put evidence before this panel that pursuant to these procurement proceedings, they are highly relevant. Despite my learned friend's submissions, they're highly relevant because these policies that have been placed before the panel, if in the course of these proceedings the panel were to find there was any non-compliance, which we do not accept and do not concede that there was substantive non-compliance, but we are saying in the alternative, even if the applicant were to succeed, there are innocent third-party rights involved here, which I will go a little further into, but there are innocent third-party rights involved here that the panel must have regard to, in accordance, not because I am making this submission, in accordance with law. The panel must have regard to subsection 6(2). Must have regard. And so it is relevant to these proceedings because the applicant is asking for the contract, award of contract to the interested party to be cancelled and for this to be reevaluated. What that means is that aviation policy, and you see, I would have wanted to do these submissions at the end after the evidence around these aviation policies are put before the tribunal. But as the evidence will show, these aviation policies will lapse if there is any order to cancel the award of contract. What that means is that the Trinidad and Tobago Civil Aviation Authority, that has the statutory responsibility to protect our airspace, and it is not only a national mandate, it is a global mandate. There are global obligations, treaty obligations in respect of air service, air navigation service providers. If the air aviation policy is to lapse, which will happen if this panel were to be led into a decision being advanced and persuaded by the applicant to cancel the brokerage contract, what will happen is the minute that aviation policy lapses, the citizens of Trinidad and Tobago, the government of Trinidad and Tobago, will now be exposed to hundreds of millions of dollars US.
I object. Mr. Chair.
I allowed my friend to speak.
I appreciate that, Ms. Rose, but I know that I'm entitled to object. I wish there was a different way to do it if we weren't on this platform. But I only wish to say, if the panel will allow me, that we are now getting into submissions that are not relevant to this issue of the, my friend has gone in almost to closing submissions, and I must say, and to the evidence. But there's filed evidence before you, and there's evidence which is not before you. And that is what we are discussing. Is the panel going to accept that this evidence can be adduced at this time? And I have heard what, I'm not sure how we're getting into these submissions about the consequence of. The question is, can these documents be disclosed at this late stage by reference to the rules or and the principles of fairness and justness, and are they relevant?
Mr. Chairman, please, but Mr. Chairman, please, this cannot be fair to me because I have not finished my response to my learned friend. I have not finished my response. She was allowed to come in before I completed the development of my points. Please, Mr. Chairman.
Thank you, Ms. Rose. As per your note, before we continue, I'd like to remind parties of the ground rules in terms of if they wish to interject, to use the features available to them. Ms. Fitzpatrick, earlier on I would have noted your hand was up, and it was the intention of the panel to ask you to, if you had a response at that point in time when Ms. Rose had completed her submission.
I do apologize, and I actually didn't realize that I had put it up. But I apologize to my friend for not utilizing the proper function of the hand raising. But I will withdraw my objection, as it were, until the panel is able to hear me.
Thank you, Ms. Fitzpatrick. Ms. Rose?
Thank you, Ms. Fitzpatrick and Mr. Chairman. My submissions are entirely relevant to the overriding objective before this panel to treat with cases fairly and justly. And treating cases fairly and justly has been explicitly set out what that means. It's set out in your rules. And the first principle is that in making your decisions, you must deal with the case in ways which are proportionate to the importance of the case, the complexity of the issues, the anticipated costs, and the resources of the parties. So my submission about the nature of the aviation policy and the consequences of lapse of the aviation policy are related to that first principle in terms of how you consider what is fair and just. Because, Mr. Chairman, you must have before you all of the relevant information. This is not a court of law where parties are constrained by what they pleaded, and if they didn't plead this, well, then this can't be addressed. It cannot be, because we are dealing with a very crucial function of modern government, which is public sector procurement. And you are given wide and broad powers, correctly so, to be flexible with your procedure. And what I am attempting to submit here is that if we carry on with this procedure without having all of the information before this panel, which will relate, they're exceptionally relevant to the panel's power to cancel a contract, the proportional decision-making power to cancel a contract, it is exceptionally relevant. We acknowledge that there were previous opportunities to put this evidence in. But at the end of the day, Mr. Chair, you must deal with the issues before you fairly and justly. And if we're looking at fairness and justice, it's not only in respect of fairness and justice to one of the parties or other of the parties. It must include the complexity of the case, and therefore the impact of your decision to cancel. And the Act clearly understood that if innocent third-party rights, this is a very old principle in commercial law, and so the framers of this legislation were very careful to codify it, very careful to ensure yes, we are saying it's void, but if innocent third-party rights will be affected, then we cannot have that relief cancellation. And to my learned friends quoting learning relating to a contractor and a subcontractor in the construction industry, I would say is not relevant to the specificity of insurance coverage and insurance contracts, because the cancellation of an insurance contract is not just affecting third-party rights in terms of the insurance provider and the person who took out the insurance and or the insurance broker. It is also the beneficiaries of the aviation policy that is now in place. Those are innocent third-party rights. The beneficiaries of the aviation policy and the motor vehicle policy. Please, Mr. Chairman. And so it is highly relevant, and it would be wholly unjust for you not to allow this information in. You'd be taking a decision that potentially could cause catastrophic harm. And I'm not saying this to be exceptional. We have put evidence in before this panel already about the consequences of a lapse of aviation coverage. And it is for that reason the broker would have acted immediately, knowing that the coverage was going to expire on September 30th. After they were informed, they immediately began their process to get at least, they didn't get the group health and life, so nobody was rushing to get everything in place. But they knew with respect to aviation policy and in respect of motor vehicle policy, because if motor vehicles, the fleets are not covered, then all operations are ground to halt in respect of use of vehicles in TTCA. This is a case where urgent public interest considerations applied during the course of the process, and urgent public interest considerations continue to apply today. If that aviation policy lapses, we are in a world that is catastrophic in terms of the harm to citizens of Trinidad and Tobago, the lack of contingency funding and contingency finance in place in the event of some problem on an aircraft. Secondly, hundreds of millions of US dollars that the government, TCA is a wholly owned enterprise of government, that the authority of government, that the government will be exposed to, plus the loss of the power over our airspace from international treaty obligations if we do not have particular things in place. And Millard, I'm not sure, at the end of the day, I'm not sure, where Ms. Fitzpatrick's point is coming from in the context of relevance. One, highly relevant. Two, in terms of justice, you have to weigh the justice, fairness and justice in its case, which is not just about the two parties before this honorable panel. It is not about just the two parties. The Trinidad and Tobago Civil Aviation Authority is a singular public sector entity here with responsible statutory mandate to keep our airspace safe. And on that basis, please, Mr. Chairman, I am asking that you allow us to help you to make the best decisions here in accordance to your overriding objective and on behalf of the citizens and the government of Trinidad and Tobago.
Thank you, Ms. Rose. Thank you for completing your submission on these preliminary points. The panel will take a short
Mr. Chair, I'm unable to hear if you are speaking. I'm not sure that if there's a drop in the connection.
Forgive us, Ms. Fitzpatrick, do you have any closing remarks?
Yeah, I will be brief, please, Mr. Chair. Mr. Chair, the applicant, I understands very well the overriding objective, and there is nothing which precludes you, the panel, from being guided by anything, including your own common sense and reason as to what is unjust. And my friend has correctly pointed out that fairly and justly does not apply to one party only. And what we say is that, there are cases and one which, if we are given the opportunity to file submissions or to address this issue in our submissions at a later stage as well. There are cases, or there's a particular case emanating from the English courts which deals with applications. It deals with applications for early specific disclosure and procurement cases, but it does provide useful guidance in this application because it sets out certain principles with respect to procurement and disclosure. And if I could just highlight two of those principles. The judge in that case said, first, an unsuccessful tenderer who wishes to challenge the evaluation process is in a uniquely difficult position. He knows that he has lost, but the reasons for his failure are within the peculiar knowledge of the public authority. In general terms, therefore, and always subject to issues of proportionality and confidentiality, the challenger ought to be provided promptly with the essential information and documentation relating to the evaluation process actually carried out, so that an informed view can be taken of its fairness and legality. And if we pause there, please, Mr. Chair, what this highlights is that these parties are already on unequal footing when it comes to fairness and justness. It is the respondent who has all of the relevant information within its possession. And it is not until the applicant files its proceedings that it can be, it is aware of those documents or that information. And that is why it is incumbent upon the respondent to promptly inform the applicant and inform its case as soon as that information is known to it. The judge continues that this should be the general approach is confirmed by the short timelines imposed by the regulations on those who wish to challenge the award of public contracts. The start of the relevant period is triggered by the knowledge which the claimant has or should have of the potential infringement. And it goes on to cite a case saying the requirement of knowledge is based on the principle that a tenderer should be in a position to make an informed view as to whether there has been an infringement for which it is appropriate to bring proceedings, or we say in this case to continue proceedings. So this highlights, please, the unfairness in the procuring entity in particular coming at a late stage to disclose documents, because the applicant's case is framed on that information which is known to it. And I would only, just two short points. As to the complexity argument that's raised, the respondent has filed lengthy, or I should say, has included a lot of information and a lot of evidence addressing the issue of the risk involved in a lapse in coverage. And we have evidential objections have passed. We have taken no objection to that. What is now being introduced is documents relative to a new issue. So I appreciate that there are issues of complexity which my friend intends to submit on, but this issue of innocent third parties is an entirely new issue. And we maintain that it is an irrelevant one, because although my learned friend is saying that what the Act does is codify that innocent third-party rights are affected, what the Act does is codify that innocent third-party rights are not affected. They are preserved. So I didn't give a construction example. That was an illustration that I came up with. And to make it even more clear in these circumstances, in that example, what we are seeing is TW would have enforceable rights as against the procuring entity. And that is what the Act is doing, is preserving W2W's rights. And again, if the respondent's argument is accepted, Mr. Chair, it would mean that anyone who enters into a contract in breach of the Act could say, there are subcontractors who are affected by this, they're innocent subcontractors. So you panel, you can't exercise your functions under the Act. That cannot be that can't be correct. And unless I can be of further assistance, that's my final remark, please.
Thank you, Ms. Fitzpatrick. For the benefit of the panel, could you reference the case that you were quoting from?
Yeah, yes, please. And I would be happy to send it to all of the parties and to the court. It's Roche Diagnostics Limited and Mid Yorkshire Hospitals NHS Trust, 2013 EWHC 933.
And if I may say, Mr. Chairman, that case actually supports the issue of disclosure and allowing disclosure. But my learned friend is being allowed to cite case law and all of that. I'm going to ask this panel, this is a very important issue for us, and we are asking you not to make a decision quickly. We would like an opportunity to put our submissions in writing on this point. So Leonard friend agrees, we can we do so.
Thank you, Ms. Rose. The purpose for the panel asking for the cases that it was quoted and we wanted some reference. Would the representative of the interested party have any comments to make? Would there be any contributions from the interested party?
No, please, Mr. Chair, we don't believe we could be of any further assistance at this point as it relates specifically to this point.
Thank you. We have just received a lot of information. At this point, the panel would be taking a short break to confer on the points just raised. We would be back with you shortly. It wouldn't be as long as a break as the stand down, but we just need a moment to confer, and we will get back to you shortly. Please stay online. You may mute your cameras while we are conferring.
Grateful.
Great. Members of today's proceedings, we are back. The panel would have conferred and a decision has been made. But before we proceed though, Ms. Rose, the panel, we're having some difficulties seeing the participants due to the distance that you are away from the camera. Is it possible for you and your team to sit a little closer to the camera? Thank you, Ms. Rose and team. That is a little more acceptable. Yes. As the panel was saying, we have considered the submissions made by both the applicant and the respondent with regards to the documents that would have been submitted recently, and that were discussed at length by both parties. And the panel, in accordance with section 14.2 of the regulations, that section allows us to admit subsequent evidentiary documents, and we feel that it's relevant because we need as much information as possible in order to come to a decision that's fair to all of the parties concerned. It doesn't mean, however, that we have accepted the argument relative to the innocent third party. It's just that we need to review all of the documents at hand in order to guide our decision in this important matter. So, on that note, though, in terms of witness Suklal Singh, we would be requesting that Ms. Suklal Singh present her evidence on Monday. This is to permit the applicant as well to consider all of the documentation that has been received today, and that will give her the opportunity to, and the panel as well, to review and to prepare for her cross-examination. So that would be our ruling in terms of the documentation submitted.
I'm grateful, Mr. Chair. Mr. Chair, I don't know if what my friend intended to do was file an additional witness statement. Is it supplemental?
Ms. Rose, would you like to respond? Please respond.
No.
You are still on mute, Ms. Rose.
Oh, yeah. Mr. Chairman, what we had intended, because we understand the strict timelines in terms of the panel having to make a decision within 20 days, was to tender the documents and have the witness give the evidence viva voce before you. And we would like to do that on Monday as well, as opposed to witness statements. And because at the time that we're going to finish here this evening, a witness statement before Monday, I'm uncertain, and we really do want to ensure that on Monday we are prepared to make full and comprehensive submissions before this panel. I'm not sure if I was clear. So, Mr. Chairman?
Thank you, Ms. Rose. You were clear.
Okay.
So your witness would be allowed to speak on these documents recently permitted, and that will be done in her statements and on Monday. Yeah.
And Mr. Chairman?
Yes, ma'am.
Thank you.
Miss Rose, you are breaking up, or we are not hearing you. Are you speaking?
All I said, Mr. Chairman, was, and so we can tender her as a witness on Monday, and she can give the evidence at that stage. Is that correct, please, Mr. Chairman?
Yes, Miss Rose, that's correct.
Thank you. Much obliged.
Additionally, yes, participants, additionally, the applicant would have the opportunity to, in terms of the written submissions that are due on the 15th, to vent the issues even further. All parties would have the opportunity to vent on what has been presented today, what has been submitted on your written submissions, which would be due on the 15th after we have gone through the proceedings today and on Monday.
Mr. Chair, I must admit that I was not present at the case management conference my colleague held for me. I was not aware that there was a direction for written submissions. And was that contained in the order?
I don't have a recollection of that, Mr. Chairman. I'm looking at the order myself. I can't recall having made that decision.
No. Apologies for interrupting you, ma'am. No direction was given for closing submissions. It is usually a part of the process where we would indicate when we have moved even further and we are at a close, that we would give all of the parties that opportunity and give them a timeline by which to make those submissions.
So just to be clear, Mr. Chair, there will be no oral closing submissions on Monday.
It could be and or. And or.
Okay. Understood.
If the parties feel that their case would be strengthened by addition of the written submissions, you have that opportunity. So it can be and or. interested party, any submissions?
No, please, Mr. Chair.
Okay, then. So we would be moving along in the proceedings. So we would have discussed at length a lot of the preliminary submissions, and we just gave some directions in terms of the documents newly presented and how we're going to proceed continuing on Monday. I would, at this point, like the parties to confirm that the witness statements and that the witnesses are present and able to give evidence and to be cross-examined, with the exception, of course, of Ms. Rhonda Suklal Singh, for whom the documents were tied to and that would be further vetted through her witness statement and her witness presentation. So for the applicant, your witness would have been Mr. Brent Mitchell, which was filed on the 8th.
That is correct, Mr. Chair, and Mr. Mitchell is present and he is available for cross-examination.
Thank you. For the respondent, Mr. Felix Pearson, you would have filed that on the 8th?
All witnesses are present for the respondent, please.
All witnesses present. Thank you, Ms. Rose. At this juncture, we would move to the presentations of the case by the parties in the manner set out in Section 10 of the Hearing Rules and Procedures. To summarize, the applicant or his representative will be invited to make any opening statements and to call the witness, after which the respondent or its representative will be allowed to cross-examine that witness, followed by the interested party or their representative. Panel members may also be asking questions, following which the applicant may be allowed to re-examine the witness if the need arises. This procedure would be repeated for all of the applicant's witnesses. There's only one witness for the applicant today, so that wouldn't apply. And similarly, for the respondent's witnesses as well. We have an interested party present today, so at the end of the presentation of the respondent's case, the interested party or representative will be invited to make any opening statements or call on his first, or call any witnesses. However, that's not applicable in this case as no witnesses were presented to the panel. Therefore, I now invite the representative of the applicant to present your first witness. However, permit me a short break. Don't go anywhere, we'll be right here. Please note that the other witnesses are not to be present in the proceedings while the first witness is presenting. They may remain after they are presented, but the other witnesses who have not heard anything from the witnesses before, they are not to be present in the room. So, Ms. Rose, that will be more applicable to you, seeing that you have multiple witnesses.
They're all secured in another room. Please, is it that the tribunal would want us to bring each of them in here, or they should come in a separate room, you would advise, when giving evidence?
If it's convenient for them to appear in that room with you, it's allowable. If they're presenting online on their own, we would need to verify that they are alone. So we would ask them to move the camera around to ensure that they are alone. But if it's convenient to you, they may come into the room that you are in now and give their statements and be cross-examined by the applicant's representative.
Intention is for them to come in here in front of you, please, in the room. Okay.
Thank you, Ms. Rose. Representative of the applicant, you may call your first witness.
Thank you, Mr. Chair. Mr. Chair, for the avoidance of doubt, I know that you mentioned that we would be inviting to open, but we have, of course, filed our skeletal submissions. So we rely on those, and we'll save any further submissions for closing, especially in the interest of time. So the applicant now calls Brent Mitchell.
The support team will now administer the oath to the witness. Chairman Secretary.
Good afternoon. Could you please repeat after me? I,
I,
please state your name,
Brent Mitchell,
do solemnly,
do solemnly,
sincerely,
sincerely,
and truly affirm
and truly affirm
that the evidence
that the evidence
I shall give
I shall give
to the hearing panel in this case
to the hearing panel in this case,
shall be the truth,
that is the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
You may proceed.
Witness tendered for cross-examination, or is my friend going to lead?
No, I do apologize. The witness is standard for cross-examination.
With your leave,
Ms. Rose, are you speaking?
I'm speaking now.
Okay, great.
Yes, please. Good afternoon, Mr. Mitchell.
Good afternoon, Ms. Rose.
Yeah, how long have you been in the business of insurance brokerage?
20 years.
20 years. And can you define what insurance brokerage services are?
Well, we provide as an intermediary insurance. Our insurance brokerage services is to find the best terms and conditions for our clients with various insurance carriers.
Yeah, that's what you do, but what are insurance brokerage services?
Placing of insurance policies with insurance carriers on behalf of our clients. We arrange it for them as a company.
And would you say you are under any duties in the conduct of those services?
Absolutely. Insurance broking is the only profession that requires professional negligence insurance. We provide a professional service.
No, lawyers require that as well. It's not the only profession. But Mr. Mitchell, and so why is that? I want you to help us understand the duties of insurance brokerage services.
Well, like any other professional service, clients are relying on our advice in making their decisions. So in that regard, there's a negligence, a professional duty attached to that advice.
And would you say there's also a duty to act ethically?
Of course.
And there is a duty to impartially advise your client
Always.
in respect of, yes?
Always, yes.
Yes. Now, I want to turn to the proposal that you submitted. You submitted a proposal for insurance brokerage services to the RFP in these proceedings. Just for quick reference, I won't be calling out what the RFP is with the number, but the RFP that is the subject of these proceedings, you submitted a proposal, yes?
Yes.
And you understood that the RFP was for insurance brokerage services.
Correct?
Now, you did not only submit a proposal in respect of insurance brokerage services, did you, Mr. Mitchell?
Clarify, what do you mean by that?
Well, you didn't only submit that, you submitted other things, did you not?
Submitted a proposal in line with the RFP scope of services.
And the RFP scope of services, can we turn to that then? Because can we turn to the RFP scope of services at, can the witness be, how do we do this? Can the witness be shown the RFP? And the panel, can the panel go to the RFP, which is tab 1, it's A of the witness statement of Brent Mitchell, and it's also tab 1 in the record.
RFP, tab 2.
No, tab 2 of the record of proceedings, and tab 1 of the witness statement of Brent Mitchell. Point 6, page 20. Do you have it before you, Mr. Mitchell? Is there a process here where we can put on the screen the document that, yeah.
Give us a short time so that the support team would be able to pull the document up on the screen.
Thank you.
The
Yes,
support
please.
team is located it right now, and we would be sharing it on screen shortly.
Thank you.
Wait a second.
The specific section that we are going to while the team is pulling it up.
Part, and it's on page 20.
Page 12.
Yes, please, Mr. Chairman. Mr. Mitchell, do you see the part relating to scope of services?
Yes,
And you see that very specifically, it is made very express that what is required is an insurance brokerage firm to provide a range of services.
yes,
Yes?
yes.
And those services, as outlined there, would be subject to.
Ms. Rose, pardon the interruption. I would ask the witness to speak a little more clearly into the mic so that we can clearly hear his responses. The proceedings are being recorded, and that would greatly assist us. Thank you. Pardon the interruption, Ms. Rose. You may proceed.
Yes, and so those services of the insurance brokerage firm there, 1 to 7, you would be providing them subject and consistent with the duties you just outlined for us.
Correct.
Now, would you say putting in a proposal to provide the insurance coverage yourself, a self-funded insurance coverage, would be the provision of insurance brokerage services?
We did not submit a proposal to submit it by ourselves. We gave an option for civil aviation to consider a self-funded plan in which they will retain a certain level of risk, and there will be major medical cover to respond to losses, large losses. And then we also gave a second option for a fully funded insurance plan.
Yes, but that self-funded plan was a plan that was being provided by a company, your company.
No, we have a subsidiary company, Cardia Benefits, that provide administration services. They are not an insurer. They are not a broker. They provide administration services for health plans.
Right. So your subsidiary, you made a proposal for your subsidiary to provide the insurance coverage.
To administer a self-funded health plan. They are not providing insurance.
And to have your subsidiary administrating such a plan, it is your evidence that you would be able to impartially and ethically advise the Trinidad and Tobago Civil Aviation Authority of risks and issues that may arise during the course of that insurance coverage?
Correct.
Okay. I would like to go to another point raised by you. Now, in respect of the assessment of cost proposals, at the virtual opening, Mr. Chair, that part of the RFP can be removed from the screen. Mr. Mitchell, at the virtual opening, that cost proposal that was produced there, submitted there, was in respect of this self-funded plan.
That is correct. That
provided by your wholly owned subsidiary.
Correct.
Yes. Now, you've had the opportunity, I'm assuming, so I'm asking you, have you had the opportunity to read the Form 9 reply that the respondent has submitted herein?
No, I have not read it in detail.
Have you had the opportunity to read the witness statement of Rhonda Suklal Singh, the chairman of the Evaluation Committee?
Yes, I have read that.
Yes. So you understand that the explanation being provided by the Trinidad and Tobago Civil Aviation Authority for a difference in the cost proposal in the opening and the cost proposal in the evaluation report is as a result of their decision to treat all bidders fairly and objectively and transparently in respect of the scope of services that was required in this RFP.
Sorry, sorry, what's that? You want me to reply to that now?
Yes, so you would understand. Yes, I said, so you understand, because I asked you whether you read the witness statement.
I understood what.
And so now, because you did not have you did not have an explanation for, and that was, part of your issue here, that at the virtual opening, and you put this in your Form 8, you had a particular cost proposal, and then in the evaluation report disclosed in Form 9, you saw a different cost being identified for your firm. Yes?
Correct. A cost that we cannot understand where it came from.
Right, and you could not understand where that difference came from.
Correct.
And so I'm
No
asking.
calculation was provided in that document.
Yes, understood. So and then I asked you, had you had an opportunity to read the witness statement of Ms. Rhonda Suklal Singh?
Correct. And it's not there.
To which you said yes. Yes. And I said, so you would understand in that witness statement, Ms. Sukhlal Singh, the chairman of the evaluation committee, indicated that the reason for that difference was the decision of the evaluation committee to treat all the bidders fairly, objectively, and transparently.
That was the intention, but that's not what happened.
But so you understand that that was the intention.
Well, based on what they said, yes.
All right. And would you accept that that is a fair thing to do?
If they had done so, yes.
If they had done so, you would accept that that was a fair thing to do?
To calculate the correct premium for us, yes.
Well, to treat all bidders fairly, objectively, and transparently.
Yes, that's fair.
Right. Now, you are aware that you were the only company to provide a self-funded option for insurance coverage.
Yes, based on the evaluation report, it appears that way, yes.
Yes. But all of the bidders from the evaluation report, you would see, all of the bidders had submitted cost proposals on the current existing schedule of benefits for group life insurance. You would have seen that from the evaluation report. Every bidder submitted cost proposals on the existing schedule of benefits for group health and life.
Yes, yes.
And also every bidder submitted cost proposals for a insurance cover backed administratively by an insurer.
Correct, we all did.
Right. Agostini, yourself, Mr. Mitchell, you were the only one to submit a self-funded option backed by a subsidiary company.
Correct.
You are aware that historically, because you would have had access to the documents, historical documents of the insurance cover for TTCAA, you would have been aware that TTCAA had never had any direct arrangement with an insurance provider. They have always utilized insurance brokerage services. Is that correct?
This is the first time they've ever tendered their health business that we participated in. It's always been previously just their general insurances.
Yes, but my question is, you're aware from your understanding of the history of insurance coverage and the relationships established in TTCAA that they have always used insurance brokerage services and have never engaged insurance directly, insurance cover directly.
For health and life, Ms. Rose, I cannot confirm that. We were not aware of that until they tendered this year.
Okay, that's fair. But you're aware of it now?
Well, you have now clarified that.
Okay, all right. And would you agree with me that in a tender process, if you have several bidders and they have many different options, some of which were not requested in the scope of services, that it would be wholly unfair to some bidders for a procuring entity to select one option that may seem the cheapest but was not something that was requested.
So that's why
would you not agree? Sorry? You understood the question? Sorry, because I was
sorry. The tender did not ask for an insured plan. It asked for group health and life. And we gave an option for a self-funded plan for the health and an insured plan for the life. We also gave an option for the group health as a fully insured plan. So in our view, if TTCAA did not wish to enter into a self-funded arrangement, they can use the fully insured plan that we proposed as well, based on the current schedule of benefits. But what remains unknown to me is how our premium for the fully insured plan was not used for the evaluation report. But I do confirm that one of the witness statements conceded that they made an error with our premium.
Okay, so that's a lot. So let's slow it down and unpack what you've just said. So you accept that it would be fair, I'm asking, for TTCAA to be unresponsive to parts of a proponent's proposal that they didn't ask for.
But we answered exactly what they asked for. They wanted a group health plan, and we gave
No,
them
they
two
wanted
options.
insurance, but sir, I just showed you part 6. We put it up on the screen. They wanted insurance brokerage services for their insurance portfolio, which included group health and life.
Correct. But let's separate
Right.
the duties there. We will be acting as AIB, as their broker, but Cardia will be managing or administering their health plan.
Your wholly owned subsidiary.
Correct. If it is as
Right.
their broker, the plan was not
Yes.
competitive or performing well, then our recommendation would be to move the plan from self-funded to a fully insured plan, or vice versa, depending on the circumstances of the particular client.
Mr. Chair, I see Ms. Fitzpatrick's hand is up.
Thank you, Ms. Rose. Ms. Fitzpatrick, you are recognized.
You're on mute.
You're on mute, Ms. Fitzpatrick.
I apologize. Thank you, Mr. Chair. Thank you, Ms. Rose. Mr. Chair, I don't know how we do this with a witness, but I understand the line of questioning to be suggesting to the witness that the proposal was not in line with the RFP. And if I am incorrect to say that, then...
Unfortunately, I'm not able to reach the screen to put my hand up, but I would ask my learned friend. I do understand she has the utmost integrity, but her witness is in front of us and she's going into some submission that I'm not quite sure what it is about, what is the nature of the submission while her witness is on the stand. And I want to be very cautious that the witness is not led in a particular way, because this is a very sensitive part of my cross-examination, please, Mr. Chairman.
Thank you,
Yes,
Ms. Rose. Ms. Fitzpatrick?
Mr. Chair, if the witness could exit the hearing room and be invited back in at the end of my objection or submission, I think that would avoid any concerns.
Mr. Mitchell?
Is it an objection or submission? What is it?
Well, I think it would be, I will figure that out when we ventilate it, because I right now, I would like to understand if I'm correct in where you are going with this cross, and I think that would assist.
Well, Mr. Chairman, then I must object. I am cross-examining. A learned friend can articulate an objection, then you can stop me. But in the middle of my cross-examination, at a very sensitive point, to say I want to understand where my friend is going and then determine whether I'm going to make an objection, it's really not fair to me. Please, Mr. Chairman.
Ms. Fitzpatrick, do you have an objection?
Yes, I have an objection.
Okay, thank you, Ms. Fitzpatrick. Before we proceed, Ms. Sinat, I noticed that you raised your hand twice. Do you still wish to contribute?
Yes, please. While I note Ms. Fitzpatrick objection, I may be of some assistance. If we look at page 20, it's part of Ms. Rose's bundle, tabs 1 to 7.
Ms. Sinat, just hold a second, please.
Sure.
Mr. Mitchell, could you mute? We would be muted. We would be exiting you from the meeting, and we would readmit you after we have listened to counsel.
Just so I'm clear, I don't have to do anything. You all will put me in a
Yes,
meeting.
we would remove you from the meeting, and then we would readmit you.
Okay, understood.
Okay. I'm just verifying with my support team. As soon as I get clearance, I would let you know. Okay, Ms. Sinat, you may continue.
Thank you, Mr. Chair. Yes, at page 20, please, of the RFP. It specifically states the criteria, including but not limited to: 1, act as liaison between the TTCAA and the insurer for the administration of health and life insurance plans. Advise the TTCAA of trends in group health and life insurance plans to allow the TTCAA to update or amend its plans as necessary, accept claims, etc. I think my friend Miss Rose could correct me if I'm wrong, but I think this is where she was trying to marry the two and get out of the witness.
Okay, thank you, Ms. Sinat. What we would do is deal with the objection by Ms. Fitzpatrick, and Ms. Sinat, do note that you would also have the opportunity to cross-examine the witness as well after the respondent and the applicant have made their submissions. So, Ms. Fitzpatrick?
Yes, Mr. Chair. My objection is simply this: that if my friend is going down the road of suggesting now to the witness that the applicant's proposal was not in conformity with the RFP, I say simply that the evaluation report that was prepared says nothing about this, and that it is unfair at this stage and totally irrelevant to these proceedings to be raising that. That is a matter perhaps for different proceedings if we get there.
Is that the extent of your objection, Ms. Fitzpatrick?
Yes, it is, Mr. Chair.
Okay. Ms. Rose, before we continue, we are taking a short break. Let me confer with the panel. It wouldn't be long. It's just to have a conversation with the panel, and we get back to you. Please remain.
But I would, okay.
Ms. Rose?
Please.
Yes, Ms. Rose, and in light of your interaction with the witness, could you point us as to whether you're saying that whether the bid was compliant with the requirements of the RFP? And if so, can you point us to documentation in the packages where we can ascertain that fact?
I have never indicated that it was non-compliant. I said non-responsive. There are parts
Non-responsive.
of the package that were not responsive to the specific scope of services that were laid out. But that was a foundational point to the point that has been elucidated in the witness statements relating to how they got to comparing apples with apples. I am building to that, please, by starting with the nature of the services required, the nature of the services proposed, trying to make a particular point in respect of a distinction between the two. I have already elicited from the witness that he did propose similarly to others in 2 respects, and I was going further. So it's about building the case toward apples being compared with apples, Mr. Chairman.
Thank you, Ms. Rose.
Mr. Chair, in light of that, I have no objection to the line of cross-examination. That's precisely why I said it was in order to understand without having to object at a later stage where the cross was going.
Okay, thank you, Ms. Fitzpatrick. We would readmit the witness into the room, and Ms. Rose, you may continue once we verify that he is in the room and available. Ms. Fitzpatrick, we would need to ask your witness to rejoin. We are not seeing him in the meeting room.
I will do so now, please, Mr. Chair. Bear with me.
Mr. Chair, just as Melinda Friend is having her witness come back in, I'm wondering what are we putting in place to ensure that witnesses are not able to view this on live stream?
The specific links are sent to each of the participants, and at this point in time, he would not have been able to join, hence one of the reasons why he's not available. He would have been out of the meeting. On the platform, we would have noted his presence or any other presence that would have joined this particular meeting.
Mr. Chairman, I'm asking, this is just actually for an understanding of the process here. I'm asking about the YouTube stream, which is publicly available.
Let me confirm my technical team. Thank you, Ms. Rose, for that observation. As far as Teams is concerned, the witnesses or participants would not be able to enter into the room without the consent of the technical team of the panel. In terms of the YouTube feed, however, we would advise participants to advise their clients to not participate in the YouTube feed or to attempt to view it while they are not part of the room.
And I will
see
rely on the good
Ms.
faith
Rose?
of Mr. Mitchell. I will rely on the good faith of Mr. Mitchell and his counsel in this issue. Yeah. So,
Thank you.
so Mr. Mitchell, we lost a bit of momentum there, so I'm going to have to just go back. You accepted that the RFP was for brokerage services, insurance brokerage services. Yes?
Correct.
You have accepted that one of the options that you provided was related to self-funded insurance cover to be provided by is it a wholly owned subsidiary of your company?
Correct. Yes, it is.
Right. You have also accepted that it is that option, the cost proposal in relation to that option, that was made visible at the virtual opening.
Well, that is the option that we completed in the form of tender. Yes.
Yes. And you accepted that you understood, having looked at the evaluation report, that no other proponent had provided a self-funded option by a wholly owned subsidiary.
Correct.
You've also accepted that all the proponents provided a cost proposal relating to the existing schedule of benefits for the group health and life plan. Yes?
That's one of the issues with this hearing that we're trying to ascertain. That it says that, but the report is inconsistent in its content.
Is the report inconsistent in respect of that point that I just asked you, that all the bidders submitted a cost proposal in respect of the existing schedule of benefits for the group health and life plan? Is there any inconsistency on that point?
No, it's the premium associated with it for all the bidders is what's inconsistent.
Yeah, right. But is there any inconsistency on the point that all bidders provided a cost proposal relating to the existing schedule of benefits for the group health and life plan? That's
what the report says, yes.
Yes. Also from the report, all proponents submitted cost proposals related to insurance brokerage services backed by an insurer.
Yes.
Yes. So would you accept that it was fair and objective in the evaluation of these proposals? We will get to the point as to whether you think they did it properly or not. So this is a preliminary issue. Would you accept that it was fair and objective in the evaluation of these proposals for the decision to have been made to compare like cost proposals with like cost proposals?
That would be fair, yes.
Yes. Now, you indicated, well, that would be fair. Hold on, let's go there. And if after doing such calculation, AIB was not the lowest cost proposal, and on a weighted average was not the winner, would you accept that that was a fair process?
That was not the process in the RFP.
I'm asking that had they decided, had the decision been made to compare like with like, cost proposals and AIB was unsuccessful when that was done, would that be fair?
If they did that, yes.
And you would not be here today. Correct? No, I'm just asking. Right. Okay. We're just going to take this step by step and we will see where we differ. Okay? So you saw in the witness statement that decision was taken in order to be impartial with all the bidders to compare the cost proposals that were linked to the existing schedule of benefits for the group health life plan. Yes?
Yes.
Okay. So, Mr. Chair, can we have the cost proposal of AIB put up? That is at tab, I believe it's tab C of Mr. Mitchell's statement. I'm not seeing numbers on the pages though. It's quite a way down in that proposal. Perhaps the technical team could search for the name Brent Mitchell, because it's the last page where he signed. His name would appear in other parts of the document, but I assume it will only appear 2 or 3 times. So much. So if the technical team could search in AIB's proposal, which is tab C of Mr. Mitchell's witness statement, for the name Brent Mitchell, one of the items will be the page. The pages are numbered, please, Mr. Chairman, I apologize.
I must apologize. I'm trying to find the PDF page number for you if it will assist the IT team.
We are searching at this point in time as well. We would present it shortly.
Thank you. I need.
It's at page 146 of the PDF, I believe.
I didn't hear.
Yes, that's page 146 of the PDF. So if the IT team is able to pull it up, the PDF document has numbers.
Thank you, Ms. Fitzpatrick. We are now moving to that page. I don't think that's not the first excited.
The price schedule follows that. $155.
Well, yeah.
Ms. Rose, you can stop us when you wish.
Yes. Keep going, please, Mr. Chairman. Can we go to the last page of that, where the sum totals would be the last page of that price schedule that you're going through there? Okay, but okay, general. Wait, I have to get into this. This page. This is the last page. Go back up, please. Can the team take us up further so we can have on the screen both option 1 and option 2?
I did.
Stop, please. Stop. No, not so far up. Halfway through the page. After. Oh, stop right now. Yes, thank you. So even before we look at this, I just want the confirmation. You have no problem, or do you have a problem with the price calculations or the cost proposal set out in the evaluation report in respect of the aviation policy? Your cost proposal, where's Mr. Mitchell? Not seeing his face. Okay. For some reason, I'm not seeing you, but that's okay. But Mr. Mitchell, with respect to your cost proposals dealing with the aviation policy, you don't have any problem with how that is set out, do you?
On the aviation policy, no.
Right. So is it correct? Am I correct that your cost proposal for aviation policy is $2,804,974.26 Is that correct?
The aviation policy.
Well, the general insurances outside of group health and life.
Okay.
The general insurance, the rest. Huh?
Okay.
Yes?
It is, what number did you call? Sorry.
$2,804,974.26.
Yes, that was consistent in our RFP as well.
Right. So where we have some challenges is the calculations of your cost proposals for the group health and life plan, correct?
Correct.
Right. So we're going to try to see whether we can meet each other on this issue. On the screen would be your totals in respect of the group health and life plan. Well, part of your totals in respect of the group health and life plan, option 1 and option 2, and then there's a little bit later on that we will consider, right? But the main parts of option 1 and option 2 are on the screen. Is that correct?
Correct.
Correct. And so option 1 under medical rates, option 1 self-funded, we see to get your price there, would it be correct to add $2,264,340 with the figure on the right, $247,176?
Yes. To get the retired, the premium, yes. For the health, yes.
Right. And can we get what that figure would be? 2.264340 plus 247,176.
2511516.
2511516. Right. And to that figure, because we want to get the full cost of your option 1, we add To that figure, we add
Yep.
this and this.
Yes.
Right. So can the tech team take us down a little further on the page? Group life, AD and D benefit. Thank you. Thank you, right there. So that figure that we just worked out together, $2.5 million, $11,516, we need to add the cover for the cost for critical illness, $674,347.20, correct?
Correct. Correct, yes.
Has this been doubled?
No,
Okay.
once and once.
Right. And $4,400.64. We need to add that. Correct?
Correct.
And that would take us to your virtual opening price. Would that be correct?
Correct.
Of 5.5. Right. Now, if we can go up just a little bit more on the screen, Mr. Tech Team. Thank you. So beneath that option 1 and in the middle of the page, we now see option 2. So that is the explanation for the virtual opening price, correct? And that's what we've just worked out. We're all on the same page. Now we go to option 2. To get your price, would it be correct that we have to add the $2,876,340 to the $316,560 to the two amounts for group life and AD&D benefit at the bottom?
Yes.
Is that correct? Yes. And so can we do that now? Where would that get you? 2.876 plus 316 plus, if the tech team can go a little lower again to pull up the group life AD&D benefit. If you can go back down, Mr. Tech, right there. Right. So if we can leave this screen, we'll have the 4 numbers that we need to add right now. Is it correct that for group health and life, under option 2, that would be $3,871,647.84? $647.84.
Yes.
And then 3.867 million plus the 4.
This is it. What you have is correct. 3,871,000.
Let's make sure we have the same figure. And this is a little $3,871,647.84.
Yes, I'm seeing that.
Right. And when we add that to what we already agreed was your price for general insurances, including the aviation policy, which was $2.8 million.
2,804,000.
$2,804,974.26. When we add that together, what is the price that you get?
Sorry, for option 1 or 2?
We're doing option 2, Mr. Mitchell.
Lots of numbers and okay. 6,676,622.11.
Yes, that is the figure in it as well. Mr. Chairman, if you would just bear with me, I am looking for one particular document which in this pile that I have here seems to have so weird. Okay, give me another copy. I don't know where that went. Apologies. Right. Now, have you seen the witness statement of Bear with me, Mr. Chairman and Mr. Mitchell, my apologies.
One.
Ms. Rose? Ms. Rose?
Yes, Mr.
Could you guide the panel as well so that I can ask the technical team so what document that we're looking for so we may assist?
Yes. So before we take this down, we're just concluding that we all well, Mr. Mitchell, we are on the same page in respect of the overall cost of option 1 and the overall cost of option 2 as per your cost proposals. Yes?
Yes.
Okay. We would like now to look at the witness statement of Rhonda Suklal Singh, the chairman of the evaluation committee.
Ms. Rose? Ms. Rose?
Yes, please. Yes.
We would have previously determined that the witness statement and any references to it would be referred to on Monday.
Oh. I didn't understand any references to it, but I will be.
That would have been in light of all the additional information provided with the documentation. And you would have guided us that the additional documents provided this morning would have been tied to Ms. Suklal Singh's witness statement.
Yes, but on the new issue, on the new issue relating to the intervention of third-party rights, but on the evaluation, we had set it out. But I can attempt to get at it maybe in a different way with the witness if.
Please.
Mr. Chair,
Please do.
if I can be of any assistance, I have no objection to the witness being directed to anything in Ms. Suklal Singh's statement. I don't know that it would be fair to have my friend cross-examine without it.
Ms. Rose, you may proceed given the contribution of Mr. Fitzpatrick.
Very grateful to my learned friend and the panel. Yes, I would like, can we look at the witness statement of Ms. Rhonda Suklal Singh, page 7.
You may stop us when you reach the relevant section. It is on screen now.
The end of page 7, please. Yes. You see Mr. Mitchell, and in service of our duty of full disclosure, the chairman of the evaluation committee conceding that there was an arithmetical error which was made in respect of your pricing in the calculation.
Yes, I saw that.
I will stop on that issue, please, Mr. Chair. I'd like to go back to the previous document. I apologize for this, which we were on with the cost proposals on the same page, which is the tab C of Mr. Mitchell's statement, page 146, was it? Thank you. Now, Mr. Mitchell, if the two figures at the bottom for critical illness were doubled, can we calculate what that price would be? I need help. We'd like to double the 674,347.20 and the 4,400 64.64, and then add that to the option 2 fully insured rates at the top of this page here that we're looking at.
7355. 7355-369.
And is that one of the figures we have here? Right.
Yeah?
Yes.
Okay.
It should come up to 7355-369.94. Are you with me, Mr. Mitchell? I can't see you on my screen, so.
No, I'm trying to keep up, but I'm not getting the figures that you're using to get that arrive at that.
All right,
What's
so
the number?
you saw Ms. Suklal indicated in her statement that there was an arithmetical error
Yeah,
in the Excel sheets. I'm asking you to double the two figures at the bottom of the page in front of you for critical annual premium, group life, AD&D, critical illness, 674,347.20 and 4,464. And yes, double those and add to the annual premium for option 2 fully insured, and you should get the figure 7,355,369.94 total costing after evaluation of the AIB proposal as set out in the evaluation report. I just want to see if you can get to that calculation.
okay. $7,355,369.94.
Yes.
Okay.
Okay. So do you see now how, I understand what is happening, but do you see now how your figure for your total final costing for your option 2 for both parts came up to that figure of 7,355,369.94?
Yes. Thank you.
Yes. And at that level, you, at the end, were ranked second. Correct?
Yes.
Yes. Now, in fact, you should have been at 6.676, $6,676,622.10. That should have been your figure, correct?
Correct. Yes.
Yes. And I respectfully submit to you that even on that figure of $6,676,622.10, you remained the second ranked bidder.
On the witness statement, yes, that's what it said.
Well, based on the way the evaluation was done, and we're going to come to that, but based on the way the evaluation was done, you accept that even with the arithmetical error, you remained the second ranked bidder.
Yes.
Okay. Now I want to turn to the evaluation methodology, because in written submissions of your counsel, it was suggested that there was a failure to disclose the evaluation methodology. Yes?
Yes.
Right. So I would ask the panel, please, can we have the RFP put back up on the screen, which would be tab 1 of the Brent Mitchell statement or tab 2 of the record of procurement proceedings.
Yes, Ms. Rose, the
Now-
team is searching for the document now to put up. It will be up shortly.
And that's fine. And I can continue asking questions. Now, Mr. Mitchell, you are a seasoned tenderer,
Yes,
right? So you would understand that if in a RFP it is stipulated that the methodology would be on a weighted average, you understand what that means?
yes.
Well, can you help us with that?
Well, the tenderers will apply weightings that they determine are important for them to your scores.
The tenderers,
The
the procuring entity
yes, the
would
procuring
apply weighting.
they will apply a weighting scale based on different criteria that they feel are important for the evaluation of whatever they're bidding for, putting out for bid.
Yes. And can we go to part 17 of the RFP, please, which is on page 8 of the RFP?
It would be page 15 of the PDF.
Well, would you when they're searching, while they're searching for it, I will just ask you from your memory. Do you remember that in the RFP it was set out that the proposals would be evaluated, be a weighted evaluation criteria?
I'm looking at it, yes.
Yes, so you remember that,
Yeah, it's on page 9.
right? Is it 9? Well,
So
it's on my
9 of the
page 8.
Page 9 of the RFP is the actual table.
Yeah, that's the table of
Yeah.
some of the weighted averages with respect to the technical criteria. But I'm on page 8. On page 8.
Yes, I'm on page 8 too. If I could just help
Right.
Commission, it's PDF page 14. They're all the way at 98. One four, not 49. 1-4. There you go. Scroll down.
Yes, just right there. Just starting there. You see right there. Thank you, Mr. Tech Team. Under evaluation of proposals. Proposals received shall be subjected to a combination of pass, fail, or yes, no, and weighted evaluation criteria.
Yes,
Correct?
yes, yes.
So you were told what the methodology would be.
Yeah, yes.
Sorry?
Yes.
Okay. I also would like to go a little lower down to 17D. 17D.
Ms. Rose?
Yes.
I note that Ms. Fitzpatrick has raised her hand. Ms. Fitzpatrick, do you have a...
Well, again, I mean...
You're on mute, Ms. Fitzpatrick.
Mr. Chair, I suspect that Ms. Rose would like for the witness to be to leave the hearing.
But what is the objection? Instead of putting him out and then just...
I'm cautious that perhaps I start to speak and you tell me that he ought to be put out of the room. So out of an abundance of
because
caution,
I do want him to be put out of the room, but I mean, it's getting later and later.
Well,
Okay.
Ms. Rose, it's getting later and later, but through no fault of the applicants, and I'm entitled to take an objection. This is an important objection, so I ask to be heard, please.
So, Ms. Fitzpatrick, just to be clear, you are raising an objection and
Yes,
we would
ma'am.
like the witness to be removed from the room.
I think, in fairness to Ms. Rose, that ought to be done, please.
Okay.
I would like the witness removed, yes.
Mr. Mitchell, you would be removed from the room, and following the deliberations, you would be asked to rejoin once again.
Okay, just so that the last time, just to be clear, I was removed from the meeting, not put in a waiting room. So is it that Ms. Fitzpatrick will call me again to rejoin? Will that be the protocol?
Yes, Mr. Mitchell.
Okay. Thank
Same
you.
process will apply.
Okay.
Ms. Fitzpatrick?
Yes, thank you, Mr. Chair. Mr. Chair, my learned friend has taken the witness to page 8 of the RFP and has asked him to confirm, among other things, that he notes that the evaluation of proposals shall be subjected to a combination of pass, fail, yes or no, and weighted evaluation criteria. He has accepted that. And this is all in the interest of having him accept that the applicant was aware of the criteria being assessed. She's now moving on, as I understand it, to 17D. But in fairness to the witness, I think he ought to be taken to every paragraph under the evaluation of proposals, or at least those relevant to pass, fail, and weighted evaluation criteria.
Mr. Chairman, I am flabbergasted by Ms. Fitzpatrick's conduct here. These are issues that can be dealt with on redirect. If Ms. Fitzpatrick cannot tell me how to conduct my cross-examination, in what way am I being unfair to the witness by asking the witness if this is correct and this is what he understood?
No, please, Mr. Chair.
If at the end of my cross-examination, my learned friend is of the view that I have left any point hanging that she thinks is her favor, it is for her to make an application to re-examine her witness and take them to the point that she thinks that I have not highlighted. I am not here to do the applicant's case.
And Mr. Chair, this is not about the applicant's case. This is about being fair and transparent, not only to the witness, but to you, the panel. So the witness is being asked if they were made aware of the evaluation.
I'm sorry, please hear me, please.
Before any of the
it is not
speak.
Mr. Chairman, please. It is not appropriate during the course of my cross-examination, when points are being made, for counsel to seek to make submissions before this honorable panel. It is not appropriate during the course of my cross-examination for this to happen. This cannot be fair to the respondent. My learned friend should allow the evidence to be given freely. I am not being unfair to the witness. So I'm very concerned because...
Mr. Rose, are you finished or are you continuing?
No. But I'm grateful for the opportunity to have made that point on behalf of the party that I represent.
Thank you, Ms. Rose. And Ms. Fitzpatrick, before we continue, I would like to remind the participants of the protocol in terms of allowing each person to speak, and let us not have any crosstalk while another participant is giving their views or making their presentation. And Ms. Fitzpatrick, do note that you do have the opportunity for re-examination during the proceedings.
Thank you, Mr. Chair. I would only like to state for the record again that this is not about highlighting what is in the interest of the applicant, but I will hold my objections because it seems that there is no scope for objections within these proceedings at this time.
Ms. Fitzpatrick, to correct you, there is scope for objections.
But Mr. Chair, I apologize. I do not mean on your behalf at all. But I see that my friend takes strong objection to me raising anything. Any objection that I take will entail me making some submission to this panel. But if my friend is offended by every objection that I take, which I maintain, I'm well within my right to take on behalf of my clients and in my client's best interest, then I think that it's best in the interest of time now that we have spent so much time basically permitting the respondent to take its time to disclose documents and so on, I will reserve my objections for submissions to allow us to finish in time with respect to this panel.
Thank you, Ms. Fitzpatrick.
I want to apologize to this panel and to my learned friend if, I came across heavy-handed there. At the end of the day, I am cross-examining a witness. My learned friend has, again, sought to, in my view, make a submission. There is no real objection. If the objection is I'm not asking questions that she once asked, that certainly is not a real objection known to law, right? And so I'm sorry that I may have come across a bit passionate. I certainly do not want to stop my learned friend from taking appropriate objections, real objections. But this intervention, which has again cost us a lot of time, and I've lost momentum, right? And I'll have to go back and build to where I was going again. This objection is basically, I don't like the fact that Ms. Rose asked a question of one part of the document and didn't ask a question in relation to another part of the document. How can that be fair and appropriate? And that is all. I'm sorry. I'm not, I have the utmost respect, and Ms. Fitzpatrick knows that for Ms. Fitzpatrick. I have the utmost respect for her and for this panel. But it can't be fair. And I do want to finish, and I am going to finish very shortly. I certainly don't want to take up very much more time. But there were certain allegations made on those written submissions, and I just want to ensure that I have the confirmation from the witness mouth, the mouth of the witness, as to his understanding of this RFP that he was responding to. And I apologize that this has gone this way.
I'm grateful to my friend.
Thank you, Mr. Rose.
Yeah.
Mr. Fitzpatrick, you may call the witness back to the proceedings.
Hello?
Yeah. Ms. Rose, the witness is back in the room.
Thank you, Mr. Mitchell. Can you see on the screen 17D?
I can.
Yes, evaluation of commercial proposals.
Yes.
Right. So you see there only proposals that pass the technical criteria, having earned at least a minimum attainable score of 50% in each of the 4 evaluation criteria and at least 75% overall, will be eligible for further evaluation. Yes?
Yes.
And on completion of the technical evaluation, the commercial proposal of proponents that passed will be considered and evaluated.
Yes.
Yes? It goes on, the commercial proposal of all proponents that pass the technical evaluation stage will be reviewed to ensure that all activities required in the scope of services were priced and that there are no arithmetical errors in the proponent's commercial proposals. Yes?
Yes.
And just for fairness, in the event of discrepancies between words and figures, the written words will prevail. In the event of discrepancies between unit prices and total amounts, unit prices will prevail. Yes?
Yes.
Right. So it's clear that your proposals would be evaluated on the basis of the activities required to be priced in the scope of services.
Yes.
And you accepted earlier on that evaluating your proposal on the basis of the existing schedule of benefits for group health and life, option 2, would have been a fair way to assess your cost proposals.
Yes.
And you accept that it was clearly stated in the RFP that weighted evaluation criteria would be used.
Yes.
There was no stipulation that it would only be used during the technical stage, was there?
No.
Thank you, Mr. Mitchell. Now, I note in your statement just one last thing that I wanted to have in this witness, and I'm finished, please, Mr. Chair. I note in your statement, in your chronology, I'm not sure that I'm seeing here, but correct me if I'm wrong, because it's been 4 days for us to go through this, well, less than 4 days. It was the 8th of October, and I have been in court on other matters, so apologies if I'm not seeing in here where you indicated that you requested an extension of time to put in your submission. But did you?
Yes, we are at the tender preparation stage.
What was the date of your request for an extension of time?
I can't say offhand. It would have been sometime in June, I imagine.
These are the dates.
Yeah, it was June 11th. Was it not?
I'll have to research that if you want to confirm.
Yeah.
Mr. Chairman, can we just pull up the record of proceedings, which we filed today, so it'll be easier to find, though I'm not sure it was numbered. But was the PDF numbered?
And if you open a PDF, it is numbered, yes. It's
Because, well, let me suggest to you it was June.
Yes, I would accept that.
You're right. I'm trying to get the actual date, June 11th. Do you accept that?
Yes.
And you asked for 2 weeks,
Yes.
and it was granted to you.
To all proponents, yes.
Yes, to all, yes, of course, to all proponents. You also made several requests for clarification as well, starting
Okay.
from the 28th. Yes? And all of your requests were duly, all of you, I'm seeing at least 3 requests from you, and there were other requests from other bidders, not so?
Correct. I believe Civil Aviation issued 6 addendums.
6 addenda for 6 clarification requests. And understandably, that caused a bit of delay in this procurement proceeding. Yes?
Correct.
And I know this is not a court of law, but out of the abundance of caution, I will just I'm closing now, Mr. Chairman. I will put my client's case, the witness. So let me suggest to you, Mr. Mitchell, that even if there were a standstill period in this matter, on an assessment of the cost proposals on a like basis, you would not have been successful.
Okay.
I have nothing further, Mr. Chairman.
Thank you, Ms. Rules. The interested party, you have an opportunity to cross-examine.
Mr. Chair, Honorable Panel, no further questions for this witness, please, my lord.
Thank you, Ms. Sina. Ms. Fitzpatrick, you have now an opportunity for re-examination.
I have no questions for this witness. No
Okay,
re-exam.
thank you. Thank you, Ms. Fitzpatrick.
Mr. Chairman, I would like to propose something to the panel based on how things have gone today, based on the delay that has been caused by our application to submit further evidence, that the date scheduled on Monday, we had set the hearing to start at 11 to accommodate me because I had another matter on from 9:30 on 9:30 for an hour and a half, 9 for an hour and a half. And I am going to respectfully make arrangements for that other matter on Monday. And I'm making a proposal to the panel that the original time that you had stipulated of 9 to try to make up some of the lost time that we've had this afternoon or this morning. I am prepared to make alternative arrangements for that matter that I have on Monday at 9. And so I just wanted to put that in the mix for the panel to make decisions on the procedures for this hearing.
Thank you, Ms. Rules, for that kind consideration. Do the other parties have any objection to the rescheduling to begin at 9, given what has happened today in terms of the delays?
No, please, Mr. Chair. The applicant would be happy to do that. Of course, we're in the panel's hands.
Yes, so we the panel agree, and that we may begin at 9 on Monday. So we would reconvene at 9 on Monday. We have all agreed, the participants, as well as members of the panel. Ms. Fitzpatrick, is that your case for the applicant?
Yes, that's the applicant's case, please.
Mr. Chair, we have all our witnesses here, so we are in your hands.
Yeah.
Ms. Fitzpatrick, you were commenting. You were saying something?
Yes, Mr. Chair, I am not sure what time the panel normally sits until, but I would say that depending on, well, quite frankly, I don't know that I would have time to complete any of my witnesses, assuming that it is not past the next hour. So with that in mind, I don't know if it would be better for us to open the respondent's case on Monday, in which case I am sure that I'll be able to get through everyone. But what I would like to avoid, if it is possible, is having to interrupt the cross-examination of a witness.
Okay. Thank you, Mr. Fitzpatrick. Let me just confer with the members of the panel, and we'll get back to you shortly.
Mr. Chair, let me just have an objection to that course.
Noted, Ms. Rose. Ms. Rose and Ms. Fitzpatrick having conferred with the members of the panel. We are in agreement that we may continue on Monday, beginning at 9. Ms. Sinat, apologies, I did not consider your position. Could you would you like to speak now, please? Thank you.
Thank you, Mr. Chair. The interested party has no objection to the matter resuming at 9 a.m. on Monday. However, Mr. Chair, as a matter of housekeeping, please, if I may, at this juncture, pursuant to the order of the Honorable Panel dated the 4th of October, please, wherein it was ordered that parties file and serve their respective submissions on preliminary issues. We can confirm that we did get the respondents' submissions. However, I'm not sure if my friend Ms. Fitzpatrick may have omitted to serve us. I don't want to speak out of line. We have not received the applicant's submissions on the preliminary issues, please, my lord. Was
Thank
any
you, Ms. Sinat.
filed?
I think Melinda Tren is speaking of the written submissions themselves, because we no longer pursued our preliminary points for which the order was made for preliminary submissions to be filed. But both the applicant and the respondent filed written submissions. I think Melinda Tren is saying she has not gotten the written submissions of the applicant.
I do apologize if the applicant's submissions were not served on the interested party, and can confirm that was through inadvertence. So I will ensure that Ms. Sinath is sent a copy of those as soon as possible.
Thank you. Nothing
Ms.
further.
Fitzpatrick. Thank you, Ms. Sinat. So Ms. Sinat, Ms. Fitzpatrick, Ms. Rose, and members of the proceedings here today, we have agreed that we would reconvene on Monday at 9 a.m. and following which we would hear the witnesses of the respondent and give Ms. Patrick, the applicant, an opportunity to review and cross-examine. So that being said, I would now like to call the proceedings today as a close, but just permit me a short while to confirm if there's any other business I would need to raise. So let me just talk to the technical team, and I would get back to you very shortly. I know it has been a long day. Okay, so we can just close, right? So there being no further issues, we may now call today's proceeding to a close, and we would be reconvening on Monday at 9 p.m. a.m. Sorry. We will be reconvening on Monday the 14th at 9 a.m. Have a great afternoon, everyone, and thank you for your participation today.
Thank you.
Thank you much, Mr. Chairman, members of the panel.
Ms. Rose.